Okay, so welcome back to Intellectual Property. In today's class, we're going to continue our discussion of trademark law by talking about the trademark infringement analysis. And specifically, in today's class, we're going to talk about infringement of registered marks. Now, of course, marks can be registered or unregistered, right? Marks come into existence merely by virtue of being distinctive and used in commerce, right? So a mark is protected whether or not it's registered, right? But the Lanham Act provides for infringement claims in relation to both registered and unregistered marks. Now, arguably, there are certain differences in terms of how the Lanham Act provides for evaluating infringement, whether a mark is registered or not. And if you have a registered mark, you can bring a infringement action under both the statutory provision for registered marks and the statutory provision for unregistered marks. If you have an unregistered mark, of course, you can only bring your action under the unregistered mark provision. The core kind of statutory difference between the two is that the statute provides that a registered mark is infringed if there's any kind of confusion whatsoever in relation to the use of the mark on a similar mark on the accused product or service. Whereas when it comes to unregistered marks, the confusion has to be about the source of the product or the relationship between the mark and the producer. So in theory, the scope of protection for unregistered marks is narrower. In practice, it's not so clear there's actually a meaningful difference between the two, right? So at least when it comes to the scope of protection provided, it's not so clear that registered and unregistered marks are different. But one benefit, anyway, of having a registered mark is that, at least in a sense, you get two bites at the apple, or at least you can bring two separate claims, one under one provision and one under the other. Okay. Let's talk first about the Kellogg v. Toucan Golf claim. So what happened here, right? Of course, Kellogg has long produced the cereal Fruit Loops, which is associated with the character Toucan Sam, who is sort of the spokesperson or spokes character, I guess it would be, for Fruit Loops. And you can see the original version of Toucan Sam on the left there, a contemporary version in the middle, and Toucan Golf Incorporated, a Mansfield, Ohio-based company, decided to start producing golf-related products with a Toucan Golf logo, which you can see in the image on the right. So that's their very classy warehouse in Mansfield, Ohio, emblazoned with their Toucan Golf logo. So Kellogg's brought an infringement action against Toucan Golf, alleging that the Toucan logo that Toucan Golf was using was infringing on their Toucan Sam mark. I'll share with you really briefly a relevant Toucan Sam advertisement.
Oh, hey, I got a birdie. Sorry, Toucan Sam. Just getting a little golf before breakfast.
Breakfast, my sorting bag. Get your clubs. Who'll be there? Follow my nose.
Get on.
It always knows.
It's Kellogg's Fruit Loop cereal.
There's natural orange, lemon, and cherry flavors. The delicious part of this nutritious breakfast.
Good.
Golfers always like Fruit Loops.
Why?
There's a hole in every one.
So, according to Kellogg's, that advertisement was at least one piece of evidence, arguably bolstering their claim that the Toucan Golf logo was infringing on the Toucan Sam mark that they own. And so the court was presented with the question of determining whether or not the Toucan Golf logo was infringing, and they went through the various factors, the 8 trademark infringement factors that have been adopted in one form or another by most circuits, in order to determine whether or not infringement was was present, or at least they purported to be looking at these factors in order to make the determination, right? So what do the courts look at? Well, first they look at the strength of the relevant marks, and they say, look, Toucan Sam, mark's been around for a long time, very familiar mark, clearly a strong mark. They look to relatedness of the goods or services. So they say, is Toucan Golf entering a market that Kellogg's is already occupying or plans to occupy, or is related to what Kellogg's is doing with Toucan Sam? And here they say, well, yes, Kellogg has occasionally branded golf-related products with the Toucan Sam logo. And of course, here we have an advertisement that kind of pairs golf and Toucan Sam. But essentially they say, look, the cereal and golf are not related goods and services. So we don't see that as trending in favor of finding a risk of confusion. They're also dismissive of the similarity between the marks, right? Pointing out that at least according to the court, the Toucan Sam is more stylized and the Toucan Golf logo is less stylized. I'm not sure I find that terribly compelling, but the court seemed to think that was the case regardless. Kellogg tried to show evidence of actual confusion without a great deal of success. And ultimately, the court essentially said, look, based on all these factors, we don't see a reasonable risk that any consumers are going to be confused about the source of the product. Or to put it another way, consumers aren't going to think that Toucan Golf products are being produced by Kellogg's. Now, why is that? Well, presumably because the logos themselves look relatively different, right? They might both be stylized, but they're stylized in different ways, right? And I think most people would not be confused by the fact that both happen to be toucans, given that they're toucans depicted in meaningfully different ways. Specifically, one of the most distinctive elements of the Toucan Sam logo is the variated color beak, which of course isn't present on the Toucan Golf logo. Moreover, the fact that they're working in very different markets seems to militate in favor of a finding of non-infringement. And here you can see how Toucan Golf is actually marketing its products today. So Toucan Gold, so sweet, they're registered. They're kind of thumbing their nose a little bit at Kellogg's, if I'm not mistaken. Notably, right, what's Kellogg really trying to claim here? It kind of seems like Kellogg's is trying to claim exclusive rights to use a toucan in relation to their products. That seems like it might be a questionable claim. After all, Guinness has been using toucans for longer than Kellogg's has. Maybe they ought to be a little careful about overclaiming when it comes to the relationship between a particular species of bird and the product that they're selling, or at least product categories more broadly claimed. Okay, so broadly speaking, how do we think about the infringement analysis? Generally, we can look at it on a continuum, right? So essentially, we kind of look to both the proximity of the goods and the degree of the similarity in the marks. And the farther you get on one end or the other, in other words, the more different the markets or the more different the marks, the less likely a finding of infringement. The more similar the marks, or the closer together the product categories, the more likely you're going to find, courts are going to find infringement under the circumstances. So essentially, this is just a fancy way of saying, right, the more likely it is that consumers would be inclined to think that a particular mark is implying a relationship between a particular source and the product, a particular source associated with the owner of a registered mark, the more likely we're going to find infringement under the circumstances. Now, we might ask if that's in practice, what courts are actually doing when they do this analysis. So let's look at the Experience Hendrix v. Hendrix Electric case, right? So what happened here? We have two different parties, both of which have a relationship, as it were, to the Jimi Hendrix estate. Experience Hendrix is effectively Hendrix's father and some of his relatives have established this business that effectively exists in order to market the Jimi Hendrix name and likeness. Electric Hendrix is associated with one of Jimi Hendrix's brothers and a business partner of the brother, who are also involved with the Hendrix legacy and also trying to market products involving Jimi Hendrix. Okay, well, what's the problem here? We've got a long-standing dispute between these two parties, and specifically, the Experience Hendrix estate has previously brought actions against Electric Hendrix, arguing that there was a right of publicity protection for the Jimi Hendrix name and likeness. I haven't talked about that yet. We're going to get to right of publicity later, but suffice it to say that under the circumstances, the court said that no, under Washington law, which is the relevant law to relevant state law to determining whether or not there are any right of publicity, whether or not there was any right of publicity inhering in the Jimi Hendrix name and likeness, that under Washington law, when Jimi Hendrix died, right of publicity died along with him. So there was no right of publicity available for Experience Hendrix, and so they had to proceed on a trademark theory instead. And essentially their argument was like, look, we produce a lot of different products that are branded with the Hendrix name and likeness, right? We have developed a brand over time, selling a wide range of different products that use the Jimi Hendrix name and likeness as a way of indicating the association between the product and Jimi Hendrix. And you can see here the little R, registered trademark, right? Okay, so Hendrix Electric goes and starts making vodka, branded with their own version of the Jimi Hendrix name and likeness, right? And Experience Hendrix brings a trademark infringement action against them, arguing that this is confusing under the circumstances. So the court has to engage in a similar kind of analysis. So it talks about the strength of the mark and says, well, the Experience Hendrix mark is very strong, right? They've been using it for a long time. It's associated with a lot of different products, et cetera, et cetera. Therefore, consumers associate the mark with the source of the products. Now, query whether that's the right way to think about this, right? To the extent that Experience Hendrix is using the Jimi Hendrix name and likeness as anything, is it using it as a trademark to indicate the source of the products, or is it using it as a way of associating the products with Jimi Hendrix, right? And if the latter, is that a trademark use or not? Or rather, to the extent that consumers associate products branded with Jimi Hendrix's name and likeness with a particular source, is that a function of the Jimi Hendrix name and likeness communicating information about source, or is it a function of the Jimi Hendrix estate doing everything in its power to prevent anyone else from using the name and likeness? Sort of hard to parse out exactly what that means under the circumstances, and one kind of wonders whether the Jimi Hendrix estate isn't trying to use trademark law to accomplish what the right of publicity was actually intended to do. Now, one wrinkle in this particular case was that because Jimi Hendrix's death was attributed to overuse of alcohol, the family intentionally refrained from using the Experience Hendrix mark in relation to alcohol-related products. Accordingly, Hendrix Electric said, look, they've intentionally stayed out of that market. They've broadcast that they're staying out of that market. Therefore, no proximity of products, right? They're not producing anything in our product category. We should be golden. The court wasn't having it, suggesting that, well, maybe Hendrix Electric would expand into new categories. Fair amount of hand waving there around the likelihood of confusion in relation to to product categories, though. Like similarly with the similarity of the marks, right? Are the marks actually similar in terms of how they look and what they say, or are they simply similar because both of them reference Jimi Hendrix? In other words, what is the court actually saying here, right? Is it asking a question about whether consumers are going to be confused about the source of the products, or is it asking the question whether the consumers are going to think that both products are associated with Jimi Hendrix? Are those the same questions? Is trademark law intended to address the second? And how should we think about this problem? Well, we'll talk about that in class, won't we?